My name is Michael Harkey. Welcome and thank you for joining us today. I'm the programming coordinator for Infotex and the moderator for today's webinar. This is What Do We Tell Those Poor Vendor Owners? Yes, for those of you who are worried that you're at the wrong webinar, this is the webinar as advertised as the 4 primary risk management goals of a contract. You can find our future webinars and past webinar movies at tour.infotex.com. What to expect in our incident response test with our latest movie? I will chat the link to everyone. Now, on to the main event. Please allow me to introduce you to our speaker. He is a managing partner here at Infotex, the awareness guru of Indiana, the man with 13 letters after his name, but he doesn't brag about that. He lets me do the bragging for him. Dan Hadaway?
Thank you very much, Michael. Welcome everybody. Thank you for joining us. Good morning. Vendor management is, by the way, a very important topic in the cybersecurity assessment tool. It's the whole domain 4, and it has really driven a lot of workload to everybody's plate. And I just like to start off by, saying that the reason why I changed the name of the webinar is because I forgot that we had originally named it, that it was going to be about the 4 principles that we must address when we negotiate a contract from an information security perspective. But I want you to know that the agenda really hasn't changed at all. I just changed the name of it because what we really have is a situation where we're required by guidance and our own response to that guidance, and then our auditor's interpretation of that guidance, to assemble a really complex process that we must walk through for vendors, and the complexity, fortunately, we've been able to vary depending on the degree of inherent risk that the vendor presents us. But I want to touch upon and try to simplify that process in a manner that we can explain to our vendor owners, because we've learned over the years that in order to get the cooperation or in order to get through the vendor management process, it's much simpler, it's much easier, it's much more effective if, instead of taking a lone wolf approach to vendor management, we enlist the cooperation of our vendor owners. And yet, if we're presenting this type of information to our vendor owners, we're not going to get that cooperation. And so I don't want to, establish any kind of notions that we're going to be able to simplify vendor management, but I do want to say that we're going to be able to simplify how we express vendor management to those who don't need to be plugged in every step along the way. And just so you know, Infotex teaches vendor management currently out of the OCC guidance, primarily because it might not necessarily be the most recent statement about vendor management, and the cybersecurity assessment tool came out after this guidance, so there's already been, even for OCC banks, an update to what we do when we do vendor management, such as data flow diagrams and that sort of thing. But the OCC is the latest guidance where a regulator tried to pull everything all together into one document that is kind of a summary of everything that the FFIEC has said, and therefore they have mirrored over the years since we invented the notion of we should probably do due diligence on the people that we're giving information to, or that are accessing information. And as you can see, this just goes on and on. It just keeps going on. And I think it's on page 18. Yeah, once we get to page 18, this is one of my favorite pages. I wouldn't recommend that you actually read this, but if you look here, this is all the guidance that the OCC summarized in their vendor management guidance. And so if you look, I mean, it goes on and on and on. This is just a list of what they pulled together when they created, OCC, 2013-29, which is this guidance that expresses vendor management. And so we definitely have complex programs. By the way, they did do a good job of summarizing and simplifying vendor management with this a very poorly presented graphic. I apologize for the way this graphic looks once it stretches out to the size of a GoToMeeting or a GoToWebinar window. But But the OCC, really, that guidance, we teach from it because it touches upon everything that we were teaching about vendor management before there was good guidance on vendor management, but also it really does a good job of simplifying the process, but not for your vendor owners. I still feel if you try to teach this to your vendor owners, we're going to lose their cooperation because it's going to be way too complex. These are, some of the diagrams that Infotex has developed over the years to try to teach vendor management. And, whenever we teach a system, what we try to do is we try to give you everything that we've ever seen from every bank. And so by the time we're done diagramming what you should do from a vendor management perspective, look how complex it ends up being. And we even have to put an overlay on our diagram that says, oh, by the way, this is the procedure document. And each of the different elements that are spelled out in a procedure. If we're taking this information and we're trying to present something like this to our vendor owners, we're going to lose them. All they're really interested in is, what's the board report going to look like and how do I get reflected in that board report? And what can I do to help you make me look good in that board report? Is probably, if we get to a gut level, what does the vendor owner think about vendor management? We might say that this is really the only part of this diagram here that interests them. We've tried to, over the years, simplify the process with diagrams like this to kind of try to spell out, and by the way, here the arrow that goes back and forth, and I'm sure a lot of you, I see in the audience, there's a lot of you that regularly attend my workshops and webinars, and so you probably know that this arrow going back and forth is actually what we're hoping the vendor manager will do, the vendor owner. The person who owns the relationship with the vendor should be the one that works with the vendor to say, hey, we did a risk assessment and we still have some high risk here and some missing controls. Is there anything that you can do to help us with this? And so, we want to keep them focused on what their role is. And I have found over the years that where we actually can catch their attention and help them the most is by helping them way in the early part of the process. As everybody has learned that, it's not as easy as Dan diagrams here, okay, because we're working with several different alternatives. Number one, do we have to give the whole due diligence request to everybody? We've got people that we just say, hey, yeah, sure, we'll give you a chance, but I almost feel guilty making them fill out all those checklists that we have to fill out because we might be giving them information or whatever. We don't even know what the price is, et cetera. And so, what we've learned is that if we get the vendor owners involved in the contract process, we're going to be in a much better position where they're going to understand their role a little bit better. They're going to be motivated to fulfill their role a little bit better. And so maybe we ought to talk to them about, what's going to happen when we look at the contract from a due diligence perspective. Now, having said that, if you look at the OCC guidance, and again, though this is OCC, I want the FDIC banks, I want the Fed banks and the credit unions that are here to realize that this is just a summary, a regurgitation of what the FFIEC has said. So if I was an FDIC bank, I'd be pulling this baby down because it's a lot more organized than all the different various financial institution letters that the FDIC has released, trying to help you understand their interpretation of the FFIEC guidance. But if you look here, contract negotiation is, of course, a big part of vendor management. And when we get to the contract negotiation section, you will see it just goes on and on and on and forever. And so do we really want to have our vendor owners, be aware of or be cognizant going into a contract of however many issues this ends up being, and by the time we get to the end of it, this is we've checked against the OCC guidance. This is exactly what the OCC would say you have to look at when you look at a contract. But we don't want our vendor owners to have to be thinking about 52 things. We're going to lose them. They won't cooperate with us if we say, hey, there's 52 things. We might say there's 52 things we're going to look at. But if you want to know what you should start establishing with your potential vendors going into a search and selection process, here's the 4 things that if the contract doesn't do these 4 things, it won't pass muster on these 52 items. That's what we really want to do with our vendor owners. We want to simplify the 52, the list of 52, to a list of, half a dozen things, and actually Infotex has reduced it to 4 different items that we should teach our vendor owners. Now, the problem is that if we try to teach them what they need to know about a contract in a vacuum, they're not going to understand it as much as they would if we give them an overall picture, a bigger picture of what vendor management really is about. And so and really when I say vendor management, I'm not talking full-blown vendor management. Again, we're trying to simplify this. And so we're really talking about vendor due diligence. And so what we want to teach our vendor owners is that, hey, if you want to try to simplify that 80-page document that we have, that's our vendor management policy and our vendor management procedure. And by the way, it's not 80 pages. I'm just exaggerating there. But if we go to one of my previous presentations, I'm sure I've got a vendor management presentation in here. This is from December of 16, but it doesn't have the program in it. I moved that out. So let's just go to an earlier presentation. There you go. The bottom line is that your vendor owners, they should be cognizant that you're working this huge, hopefully you have a 1-page vendor management policy, but you're working this huge procedure, which if by the time you pull out the boilerplate and everything like that, we're looking at this is a simplified procedure here for small banks, and it's still a 6-page procedure that we're trying to manage. We don't want the vendor owners to have to know that. What we would like them to know is that when it comes to due diligence, we just want you to remember these 4 different issues, of which contract management is one of these 4 issues. And so what I would say is that, you could also look at it in terms of, what kind of questions should we be asking of our vendors going into it when we first start talking to them about the due diligence process. Fortunately now most vendors of banks know that they've got to go through a process. And so, put them on guard that, hey, we want to be talking to you about what kind of incidents have occurred over the years. One of my co-writers in my blog, Matt Jolly, and I are working on an article about the fact that, hey, just because a vendor has an incident in the past, let's not just strike them off the list. And so I like anything else, we got to caution our vendor owners that, hey, we're not saying if there has been an incident that means anything good or bad. We just want to investigate. Well, tell us about that incident. One of the most critical questions that we've learned recently is that, the question really is how long ago was that incident? We have we're a managed security service provider at Infotex, and so we watch bank and credit union networks, and so therefore on a regular basis we are audited. And long and short of it is that whenever we have been audited, we've been asked about incidents. We're very clear that our incidents are moderate or low risk incidents, etc. But we also run into on a regular basis as a managed security service provider people who are not regulated businesses, who are now clients of ours because they had an incident. And we have as an example, we have a client, I don't even want to say what industry they're in because they're the only client we have in this industry, that engaged with us several years ago because there was an incident on their network. And so I would say that yes, when we first engaged with them, they were in bad shape. But because of that incident, they woke their management team up and they put the awareness training in place. They put the assets management, the access management, business continuity, incident response planning, risk management, all 9 yards of a good information security program, including our managed security services. And they're in a much better position now than they were when they had the incident. And so, we were looking at one of our auditors was saying, hey, we want to use a certain system to transfer information back and forth between the Infotex personnel and us. And we were like, well, you should use our secure messaging system. And by the way, that company had an incident. I mean, they've actually been hacked twice to our knowledge. If you look at the breach news, if you go to privacyrights.org, you'll read about their hacks. And our auditor pushed back on that, said, yeah, but if you go there and you look, the last incident they had was 9 years ago. We've reviewed their SOC 2, they're in really good shape, et cetera, et cetera. And so the point is, I've spent a lot of time on the notion that, hey, just because there has been an incident, it doesn't mean we can't work with them. But if the incident was last month, You know what I mean? We might want to, you know, at least pay a little bit closer attention, because that tells us that they might not have a strong posture currently. Now, we're all in the business of putting together a strong information security posture, and so we know how it goes up and down. If you bring in new technology, it might be weaker now than you were in the past. But, you know, the point here for the vendor owner is if there have been no incidents, great. You know, would they sign an affidavit, by the way, saying that? Because it's hard to believe there have been no incidents, but usually they'll say, yeah, we've got some low risk, you know, or low impact incidents. Or, you know, no, we haven't had any incidents, knock on wood, or, you know, we've had incidents, but none where we've had to notify our customers. It's a start of a dialogue. The second question vendor owners should be talking to their vendors about then is, you know, put them on guard that we're going to need to see some kind of assurance. You know, if you have a SOC 2, that's great, but usually, you know, we're not having that conversation with people that have a SOC 2. They're letting us know, hey, we have a SOC 2, so let us know when you're ready, and we'll send that to you. It's those vendors that maybe, you know, are smaller, or for some reason, you know, they don't work with banks on a regular basis. They might not have the tool that we like to use, but know that there's plenty of other tools that they might be using that express the risk in their system, or that express, you know, where they are in terms of their posture. I've found the STIG, by the way, if there's a lot of businesses out there now that are required to go through what's called a STIG in order to work with the federal government. And I feel like that's a much better assurance document than a SOC 2, and I apologize to any of my CPA friends that might be listening in. ISO certifications make good assurance documents, or just a agreed upon procedure, or just a regular audit, you know, but we want to start talking to our vendors about what kind of assurance documentation they can provide. Meanwhile, how are you transferring risk? I feel like we should have a conversation with our vendor owners about the fact that eventually when we get to our vendor due diligence review, we're going to be looking at financial statements, but we're also going to be looking at your insurance, and you know, hopefully somewhere along the way you've already talked to your vendors about we need to see your financial statements more from a availability perspective than an information security perspective. But we sometimes forget that we need to make sure that if our smaller vendors have a breach that causes harm to us, that we can be made whole, and they're not going to be able to make us whole. It's going to have to be an insurance company that makes us whole. Which brings me then finally to the 4 principles of a good contract from an information security perspective, or, you know, the 4 promises is what I call them. And so I feel like we want to make sure our vendor owners know going into this that the contract that stands up the best, because not every contract, at least starting out, is going to make these 4 promises. And, you know, we've reviewed international vendors, can't say who, but, you know, you probably have reviewed some of them where when you look at you know, you don't even get a contract. You go to a web page that is the agreement that you click I agree to when you download their, you know, system, or you sign up for their cloud-based system or whatever. But if you dive in and you review that so-called contract, you'll actually see that these international companies, and I'm talking about companies that, you know, they realize that this isn't going to stand up in court, that they could be sued big time if there's an information security breach. But what their contract actually says is we're making no promise to secure your information. And so the point being is we're still going to work with them companies. They're multinational companies. They, you know, I mean, everybody uses them, okay? But we are at least going to recognize the risk that, hey, with this company, their contract actually goes so far as to say we make no promises about securing your information. We need to recognize and accept that risk. But the reason I bring this up in this context is because we need to make sure our vendor owners realize that, hey, just because a vendor can't meet one of these 4 promises, we're not saying we can't work with them. We're just saying that we need to dig in, and I'll probably have more questions for that vendor because of the, you know, the simple fact that I've got to recognize and reflect the risk when I present that board report to the board of directors. There's many, many factors, as the vendor owners will tell us. I've already looked at many, many factors in deciding that I want to work with this handful of vendors. Hopefully, they're, but by the time they're bringing it to the ISO's attention, they already know that they shouldn't do it when they've whittled it down to one vendor, or they might have to go back to the drawing board. So, hopefully they've whittled it down to 3 vendors, and they will remind us that they've already looked at many different factors. We're just saying this is an additional factor that needs to be looked at when we measure vendor risk. And so, Michael, would you be able to initiate the poll that I would like to ask everybody?
Please, everyone, take a moment to answer the poll. You should see it on your screen. I'll leave it up for about a minute. Basically, we just like to know where you stand. And, yeah, thank you in advance.
So anyway, let's kind of drill down on the first promise. And so, I'm assuming everybody that's watching this webinar probably kind of read ahead on what the 4 promises are. And so the first promise is that is what's in everybody's non-disclosure agreements, that if they can't make the first promise, then maybe we should let the vendor owners know that, hey, we probably aren't going to be able to work with the vendor if they can at least promise to keep data secure. And so now the way your lawyers might want to word the promise are, all depending on the vendor, all depending on what you find out when you go through the 52-point checklist, that sort of thing, right? But ultimately, if they can't promise to keep data secure, we're probably not going to be able to work with them. And so it's okay to let your vendor owners know that, even though we just, said that, they don't have to meet every 4 promise, this is kind of a core promise. And they should know that, our checklist will drill down on the implications of this promise, including, destruction of data at the end of the agreement, or, conversion of data to other formats if we need the data in order to be able to, use a different vendor, and that sort of thing. The second promise then is based on the notion that they've already signed the first promise, that they've already agreed to keep data secure. And so the second promise that we feel vendor owners should know going into it is that if you break promise 1, whether, on purpose or not, you're supposed to notify us. It's the law in most states, but it's very important to us because we've got a commitment to notify our clients if our clients are involved in it, or our customers or our members in the case of credit unions. But you have to notify us within a reasonable amount of time whenever you've broken promise number 1. Now again, how that's worded is going to be up to not only your lawyers, like I said in promise number 1, but also, of course, the vendor's lawyers. And if they've already got the promise in their standard agreement, that would make me feel a lot better about them, because that tells me that they get it, or that they've worked with enough people that said, hey, not only do you have to promise to keep it secure, but you have to promise to notify us if you break promise number 1. And then again, the vendor owner should know that, hey, this is the main thing you need to understand, but know that our checklists are going to drill down on the implications of that. What framework are you using for notification? There's several other things that we might want to, establish in terms of, for an example, Infotex doesn't ever collect information about our customers, but we're still promising to notify our clients if there's been a breach because we have access to their networks. And so it really isn't as centered around customer information being breached. It's centered around our system being breached. And so, the vendor owner should realize that, there's going to be slight nuances, et cetera, that the information security officer will cover. But ultimately, if they can make promise 1, we're really hoping they're going to also agree to make promise 2. I mean, why wouldn't they? It's a state law in most states, right? Promise number 3, now we're starting to get into the area where, we're going to get some pushback maybe from our smaller, vendors in terms of how the lawyers actually word the promise in the contract. And we also have seen our multinational vendors have actually gone so far as to say we don't promise number 3. But we're hoping that at the end of the day that the contract will express that the vendor will maintain the controls that are necessary to protect the data, to keep the data secure, and also, as important and really kind of a different set of controls, to notify us, or to be aware of when the data has been breached and notify us of that. And what I tell my clients on a regular basis is, if you got somebody that's not in a regulated industry, send them that NIST document for small businesses, which really summarizes information security into the 4 processes of identifying, protecting, detecting, and responding to security risks. And again, we want to let our vendor owners know that we don't want to bore you with all the details of our checklists, but let's face it, it's going to require an information security program of some type. It's going to, we're going to require that they have an incident response program, and we're going to require, regular tests of that program, among a whole bunch of other things. And if they don't do everything, that's fine. But boy, if they don't do anything, that's something that might cause the program to slow down. And so we're just trying to make you aware of this as a vendor owner up front, so that you can, again, say that, hey, there's a whole bunch of 52 questions, but, the 3rd promise is you're going to maintain the controls necessary to keep promises number 1 and number 2. And my whole point is, why wouldn't you promise number 3 if you're already making promise number 1 and promise number 2? Which brings me to the 4th promise, and this is one that I am surprised banks are not pushing back when their normal vendors will refuse to put this in the contract, because we know they're already involved in the due diligence process anyway. And so all we're saying is that we want them to promise, and again, the lawyers will word it specifically depending on the vendor, et cetera. If we don't know they're already getting SOC 2s now and we're engaging with them because they have a SOC 2, I'd want to have it in the contract that they're going to continue to maintain a SOC 2, and maybe even include the cycle there and give them an extra year in case for some reason they have to skip a year on their cycle. But my point is that regardless of what the language looks like when the lawyers are done, your vendor owners should know that, and we're also going to want you to promise to participate in a due diligence process beyond getting that engagement letter signed or the contract signed, that it's not going to be done once we sign the contract, that every year we're going to come back and ask you for audit reports, affidavits, insurance certificates, financial statements, and other documentation, all depending on the risk that we have identified in our relationship with you. So Mike, how did that poll turn out?
Dan, I'm sharing those results now. Hopefully my mic is better. We have 14% said we don't review contracts from a cyber perspective. 0% said we have a lawyer review all contracts. 43% said we review against checklist, which may require legal review. And 43 said other.
Well, I knew there'd be a lot in the other category, just because, gosh, there's a lot of different ways to look at, contract review. I have to admit, I'm disappointed with number 1, and with number 2, I realized, oh, you know what, when we had to shorten that sentence, I kind of worded it wrong, because I would never want to have, I'm glad that it's 0% have their lawyers review all contracts. And by the way, everybody, just so everybody knows, I'm the one that wrote this sentence. But I shouldn't have said all contracts. I should have said most or some, or some other qualifier there. I work with a lot of clients, and I audit a lot of banks where there's somebody on the team who they've decided, hey, we're going to get this person all the training they need to be able to review contracts. It's a decision that was made long ago. I'm always surprised that sometimes that actually is the president of the bank with even small, with really small banks, but it makes sense, but it's still, it's always surprising because how busy a president of a very small bank is. But I'm sure that whenever whoever's responsible for reviewing that contract feels queasy about the contract, they're taking it to a lawyer to have the lawyer make them feel better about it. What we do find on a regular basis, though, unfortunately, is that the contract review is focused more on all of the old, the 20th century contract issues such as price and service and termination terms, but not the termination terms are more in terms of how much of a notice do we have to give you, what kind of an out do we have to pay if we want to terminate early, but it certainly doesn't include what's going to happen with our data. Can we get an affidavit that you're signing under penalty of perjury that says you've destroyed our information, et cetera, et cetera. By the way, you probably won't get the under penalty of perjury, but I always encourage people to ask for it. Because the way a vendor responds to it sometimes will tell you how strong they are. With that, I feel like we have yet another shorter webinar in our webinar history. Were there any questions that came in, Michael?
No questions, Dan.
Okay, well, I'm going to go ahead and turn control of this over to you then, let you finish the webinar off. I would like to thank everybody that attended, and of course, I don't know if I ever do this, but I should thank, Michael and Sophia for all the hard work that they go through to put these webinars together. So thank you, Michael, and Sophia, you don't have to say you're welcome back.
Thanks, Dan. I appreciate it. Thanks again, Dan, and I too will thank Sophia, and thank everybody that attended today, and everybody have a great day.
When you view an InfoTex webinar or movie, you do so with 4 caveats. First, you're agreeing to the terms posted at the web page listed on this slide. Second, our lawyers want you to know that what InfoTex presents is often time-dated or about new trends, regulations, or guidance, and therefore we cannot provide this material with any warranty whatsoever. Thirdly, material provided with InfoTex webinars and movies is copyrighted. You keep the copyright to material customized to your organization, but InfoTex reserves the right to use the material in other engagements and boilerplates. See our transfer of copyright agreement at the web page listed in this slide. Finally, those who view our webinars or movies may be added to an email mailing list. If you do not wish to receive notice of additional educational opportunities, please accept our apologies and please opt out at the web page shown on this slide.